South Texas College of Law, Houston. Professor Blackman clerked for the Honorable Danny Boggs in the U.S. Court of Appeals for the Sixth Circuit from 2011 to 2012, and the Honorable Kim Gibson on the U.S. District Court for the Western District of Pennsylvania from 2009 to 2011. Professor Blackman holds a bachelor's from Penn State University and a JD from George Mason University School of Law. He teaches courses in property and constitutional law and holds the Centennial Chair of Constitutional Law. He's authored 3 books, including his latest, An Introduction to Constitutional Law, which was a top 5 bestseller on Amazon. And he's also written more than 5 dozen law review articles. And you thought one was bad. And he was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He's the president and founder of the Harlan Institute, an organization whose mission is to bring a stylized law school experience into the high school classroom to ensure that our next generation of leaders has a proper understanding of our most fundamental laws. Something really kind of fun to me. I just learned this because Tori told me. He started this thing called Fantasy SCOTUS, like fantasy football. You play fantasy
for real?
SCOTUS. And so you get to determine which cases. So I just joined yesterday.
Oh, you should.
And so I'm excited about getting started. So there's over 30,000 members. And so, yeah, go check it out. And we're thankful. Sorry it's a small group, but we're an enthusiastic group. So
thank you so much. Well, thank you. It's good to be here. I've been at McKinney a couple times before. It's always happy to be back. Changing the topic. So instead of doing a Supreme Court overview, let's talk about abortion, religious liberty, and Indiana. You see, your lovely home state is ground zero of the post-Dobbs movement to litigate issues about abortion. So take a step back. For nearly 5 decades, Roe v. Wade was the law of the land. During that period, the Supreme Court read the 14th Amendment to protect a right of abortion. But lurking in the background was the basis of another challenge to abortion laws: religious liberty. In Harris v. McRae, for example, Jewish and Protestant women claimed that the Hyde Amendment, which restricts federal funding for abortion, violates their free exercise rights. They contended that a woman's decision to seek a medically necessary abortion may be a product of her religious beliefs. And in Webster versus Reproductive Health Services, the American Jewish Congress, as amici curiae, argued that given the dramatically contrasting religious views about whether and when abortion is permitted or required, state statutes drastically curtailing access to abortion interfere with protected religious conscience. But while Roe prevailed, the Supreme Court never needed to resolve the scope of religious liberty and abortion. Now they will. With the ink on Dobbs barely dry, a small crack in American abortion jurisprudence has widened into a fissure. Pro-choice groups have quickly pivoted from substantive due process, that's the 14th Amendment, to the free exercise of religion as the basis for constitutional challenges to state abortion regulations. Plaintiffs across the country have filed lawsuits asserting that abortion laws violate the federal and state RFRA, that's RFRA, the Religious Freedom Restoration Act. About half the states have them, including Indiana. RFRA requires courts to review religiously neutral laws that burden religious exercise with strict scrutiny. The claim of a RFRA right to abortion articulates 4 general premises. First, the argument goes, some religions, but not others, impose an obligation on women to have an abortion in certain circumstances. Second, laws that restrict those abortions impose a substantial burden on the religious exercise of some people's faith, but not others. Third, advocates contend the state lacks a compelling interest in protecting fetal life. And fourth, plaintiffs argue that even if the state has a compelling interest, abortion laws are not the least restrictive means to achieve that interest. Why? Because abortion laws have exemptions, for example, rape and incest. Therefore, they claim abortion laws violate RFRA. They violate religious freedom. Indeed, this claim would stretch through all phases of the pregnancy. So long as a woman can claim she sincerely believes that life begins at birth, you would have a right to an abortion up until the moment of delivery. This absolute veto on the state's police power would dwarf the pre-viability right that prevailed in Planned Parenthood versus Casey. I think it goes up and down, apparently. Dwarf. Okay. Very dramatic, really. In fact, the plaintiffs challenging Indiana's abortion regulation has made it clear the argument would entitle them to obtain partial birth abortions. They say that their faith may require abortions until birth, when the great part of the child emerges from the mother. There are legal problems with each step of this analysis. First, there's a sincerity problem. I concede that certain religious beliefs may impose an obligation on a pregnant woman to have an abortion in certain rare circumstances. I'm Jewish, and I'll admit that the Jewish teachings on abortion are very complex. But in certain rare cases, there may be an obligation to have an abortion. Rare. But there's a problem for litigation. Sincerity of belief cannot be imputed to organizations, classes, or all people of a particular faith. Second, there's a jurisdictional problem. Some pregnant women may have the religious beliefs burdened by an abortion ban, but they have to be pregnant and facing the ban. Women who are not yet pregnant don't face any burden. Courts cannot speculate about a potential religious conflict before it occurs. Third, there's a compelling interest problem. The state is owed deference when defining its own rights. Its own interests, even when it comes to difficult and hot-button issues such as the onset of human rights. Fourth, the mere existence of exemptions does not render abortion laws unlawfully under-inclusive. Tanda v. Newsom and other recent Supreme Court cases held that the existence of exceptions was proof the COVID-19 lockdown measures were not generally applicable. Therefore, strict scrutiny was followed. But that step is not necessary with RFRA. Why? RFRA automatically applies strict scrutiny. So the mere existence of exceptions for rape or incest is neither a necessary nor a sufficient condition to render an abortion law unlawful. Moreover, the arguments in Indiana and in other states would cause serious problems in other areas of the law. Specifically, if the existence of exceptions automatically undermines RFRA, then another statute that is essential to our social order and serves the state's highest interest would be in jeopardy. Murder laws. Murder laws have exceptions. Self-defense, for example, which you'll studied in 1L Crim Law. If murder has an exception of self-defense, then it's no longer the least restrictive means to protect human life. If the plaintiffs in these cases are correct, and they're not, a person with a sincerely held religious belief could invoke RFRA to take the life of another. For example, human sacrifice rituals, The Mayans did those. They were religious. Fortunately, the correct answer is that the state can protect life, whether through a murder statute or an abortion statute, while still carving out narrow exceptions for rare cases. So the plaintiffs in Indiana and elsewhere cannot state a claim under RFRA. But as a threshold matter, litigating a religious right to abortion faces difficult procedural hurdles. It's not all about the substance, procedure matters. First, only pregnant women who are in fact denied an abortion that their religious belief requires them to have can plausibly assert a RFRA violation. It is entirely speculative whether a woman who is not yet pregnant may ever suffer a burden on her religious beliefs. In these cases, some of the plaintiffs are women who are taking steps to avoid becoming pregnant. For example, they're practicing abstinence or using contraception. These injuries may be sufficient to generate what's called an injury in fact for purposes of standing. I'm skeptical. Under at least federal law, an injury imposed upon yourself, that is a self-inflicted injury, does not count. Right? You can't do something to yourself and claim that the government's injuring you. Right? You can't, stop having sex or start using birth control. Say, the government did that to me. They didn't. So I think a lot of these injuries are self-inflicted. But in any event, these prophylactic steps, literally prophylactic steps, are not regulated by the state. Nor do these actions run afoul of the plaintiff's sincerely held religious beliefs. In any event, none of the challengers assert they have a religious obligation to have an abortion whenever they become pregnant. They only claim to have such an obligation if an unusual circumstance, such as a threat to their health or mental health, were to arise. Thus, there are two events that would have to occur for one of these women would possess standing. First, she would need to become pregnant. And second, a tragedy would need to occur such that not having an abortion would harm her health. A court cannot simply presume that one, let alone both, of these events is bound to occur. The second procedural hurdle is that sincerity cannot be imputed to organizations or classes. Rather, courts must assess each member's sincerity on a case-by-case basis. And again, this sincerity can only be assessed when a pregnant woman asserts that her religious beliefs require her to have an abortion that is otherwise prohibited by the state. In my view, the only procedurally valid claim would involve a pregnant woman who brings an as-applied challenge and demonstrates that she does not fall into the abortion law's exemptions. She must challenge it as applied. RFRA was not designed to facilitate preemptive litigation that could affect a large percentage of women. Okay? So my argument really has 6 primary parts. I'll focus on the last one, perhaps more so. The first is we discuss the strengths and weaknesses of the claim that RFRA provides a right to abortion until birth. Some religions have this belief, others do not. Are these beliefs sincere? I think they're serious questions. For a lot of people who want to have an abortion, incentives are present to find faith. They find some justification, but it's not enough to discover religious beliefs on the fly. They have to be sincerely held. Next, you have the procedural hurdles. Again, none of the plaintiffs in these cases are currently pregnant I think none of them actually suffer a religious burden. You need to have a woman who is pregnant seeking a challenge. Roe v. Wade. Who was Roe? Roe was Norma McCorvey, a pregnant woman in Dallas. That is the correct plaintiff. You might also have doctors who say they have a religious right to perform the abortions, although those are a bit trickier. The third part of our argument focuses on sincerity specifically. Courts are usually cautious about probing sincerity. I think that's kind of a mistake. If people start making up religious beliefs or latching onto existing religious beliefs to try and get along, try to get out of all these laws, there's prone for abuse, there's risk for abuse. Four, I think the state will be found to have a compelling interest to protect life. If the murder statute means anything, this interest will survive. Next, the mere fact that abortion laws have exceptions for rape or incest or otherwise does not make them invalid. The government needs to act with precision but can still have carve-outs for rare cases. Now, the last part of our argument I want to talk about for a few moments. There are risks to religious freedom from a RFRA right to abortion. There are risks. The Indiana case, which I mentioned a few moments ago, is problematic. Right? The reason why it's problematic is that it misreads RFRA. RFRA was enacted based on a compromise. The courts would protect religious liberty while allowing the state to burden religious exercise, when doing so is necessary to further compelling governmental interest. In these rare cases, the government can make these burdens. But a ruling for the abortion plaintiffs based on a misinterpretation of RFRA would weaken protections for religious freedom. Why? Faced with the prospect of judicial interpretations that effectively eliminate the delicate balance underlying RFRA, state legislatures may seek to modify or even repeal RFRAs, thus abandoning heightened protections for religious exercise. Other states are looking to enact RFRAs may reconsider if faced with the choice between protecting religious liberty and enforcing other compelling interests. Any victories in this case for people of faith will be short-lived, as the RFRA compromise will be broken. Finally, we should not lose sight of what 50 years of Roe taught us. Any legal area that touches abortion will be distorted. During this period of transition, as abortion works its way through the political process, RFRA and religious freedom should be afforded a reprieve from Roe and Casey. Now, again, I am Jewish. I routinely file amicus briefs in favor of Jewish groups and those of other religions to try to ask the court to protect their religious exercise. RFRA is a key part of that advocacy. For decades, RFRA has protected religious liberty at all levels, federal and state. But RFRA has been controversial. Look no further than this state, Indiana. You may recall that in 2015, Indiana enacted a RFRA. At the time, the ACLU vigorously opposed the RFRA. They argued that it will allow people to be exempted from the law and allow discrimination of all sorts. Now, of course, the ACLU is representing the abortion plaintiffs, so everything gets turned around in the world. Nothing ever stays forever. I don't take RFRA for granted. These statutes may be enacted. If a person's religious beliefs can automatically invalidate the state's interest, then RFRA works 100% of the time. That is not sustainable. But on an even deeper level, we should look at our experience with Roe. For half a century, Roe was treated as the law of the land. During those 5 decades, the judicialization of abortion led to the distortion of many important but unrelated areas of the law. What did Roe distort? A few examples. Stare decisis, the freedom of speech, facial challenges, the tiers of scrutiny, severability, standing, and so on and so on. Justice O'Connor wrote, quote, that no legal rule or doctrine is safe from ad hoc nullification by this court when an occasion for its application arises in a case involving state regulation of abortion. Nothing is safe from ad hoc nullification when abortion is at play. Now, with the ink on Dobbs barely dry, the ad hoc nullification machine has targeted for distortion another pillar of our legal system, religious freedom. In Dobbs, the Supreme Court took the momentous step of extricating the federal judiciary from the abortion question. Now, advocates seek to bog down the state judiciaries in this same quagmire. Some state constitutions have expressed protections for abortion rights. Indeed, Michigan recently approved an amendment to their constitution protecting abortion, but Indiana is not one of those states. Instead of using political channels to achieve their end, advocates have pivoted to RFRA in an effort to justify abortion rights based on their novel understanding of religious liberty. Abortion presents a contentious social issue, which the political process is currently working its way through. The free exercise of religion will suffer if this case does to RFRA what Roe did to the free speech clause. During this period of transition, RFRA and religious freedom should be afforded a reprieve from the ad hoc nullification machine that distorted foundational American law for 5 decades. Now, where do things stand now? A trial judge in Marion County recently issued an order blocking the law on religious freedom grounds. The case is before the Indiana Court of Appeals. I filed an amicus brief on behalf of the state. My group is called the Jewish Coalition for Religious Liberty, and my speech here was largely based on the brief I filed. The Indiana Supreme Court also heard arguments on another challenge to the abortion law. This was based on the state constitution, which includes a right to liberty. We'll see how that one turns out, but I don't think either challenge will prevail for the plaintiffs. I think both ones will be turned away, and abortion, as it should be resolved through the political process and not through judges making stuff up. Thank you so much, and I welcome your questions. Thank you. Please.
You mentioned necessary jurisdiction, and in jurisdiction you're talking about no burden of speculation.
Right.
How does that work with Supreme Court case creative out of
303 Creative versus Elanis?
Yeah.
Yeah.
Is that kind of speculative?
Yeah.
Maybe I'm reading that
No,
wrong.
you are. So there's a case pending this term called 303 Creative versus Elanis. I filed an amicus brief in that case as well, but not on the standing issue. I filed a brief on the free speech issue. This case involves a website designer who claims that she would not make a website for a gay wedding. The problem for her, of course, is that no one's actually asked her to make such a website. She claims that under state law, she faces a reasonable threat of prosecution or at least a lawsuit. There is some case law governing how a person who's not yet subject to a law can challenge it. A lot of these actually came around during the civil rights era. These are fairly generous precedents. So if a person credibly fears that the state can take action against them, they can bring suit. The 10th Circuit, which again ruled against her, found that the suit could go forward. I am not an expert on Colorado law. I don't know the nuances, but at least the lower court thought it can go forward. Perhaps the Supreme Court can duck the issue, but unlikely. I think the abortion issue is a bit different because no woman can claim a present-day violation of her religious interest unless she's actually, number one, pregnant, number two, unable to get the abortion, right? The key of the case is not just can you claim an injury, that is, you're taking some actions that hurt you, but is the religious burden present today? And I don't think anyone can claim that. Question? What else? Yes, ma'am?
When you were talking about the exemption, so basically you're saying if we did allow for exemptions to abortion laws, that would allow us to go into the murder exemption laws?
Oh, let me explain that again, right? So here's the argument. The abortion law has a number of exceptions. For example, rape, incest, the life of the mother, and fetal abnormality, as if the fetus, baby would die within a certain period of time after it's born, right? What the plaintiffs argue is that, look, if you carve out all these exemptions, why can't you carve out another one for religious beliefs, right? In other words, it's under-inclusive. You have these exemptions, but not the one that we want. And that's generally, I think, a very good mode of arguing. The difficulty is that a lot of laws that are very important have narrow exceptions. I use murder as an example. So there's a self-defense exception. If there's a crime in the heat of passion, it might be manslaughter rather than murder, right? If you have intoxication, insanity, there are various defenses you can use that may not result in a conviction for murder. If we start treating laws in this exact fashion where carve-outs automatically render it unlawful, every law is subject to nullification. What a lot of people point to is the COVID cases. So you might remember there was a case from Nevada. Nevada imposed very strict attendance requirements in houses of worship during the pandemic. But casinos were not subject to the same restrictions. So if you want to gamble in Caesar's Palace, as many people as you want could be in a building. If you want to pray, you were restricted. And what the court said in that case was, look, you're exempting casinos, you're deeming them essential, but you're not exempting houses of worship, right? That argument was needed for free exercise cases because we're applying a general standard. But RFRA is supercharged. RFRA starts with what's called strict scrutiny. And then you consider what's called the least restrictive means prong. And I don't think this prong can work if any exemptions automatically renders law unlawful. So having these very narrow exceptions, which frankly have roots, right? Even before Roe, states allowed abortion for cases of rape and incest. Going back centuries, these laws existed. So I don't think these are enough to invalidate it, but if it is, this would frankly change the way it operates in a lot of different contexts. And if you don't like human sacrifice, just change it for assisted suicide, right? People can claim the right to help someone perform an assisted. Imagine a person's afflicted with a very serious ailment that creates chronic pain, debilitating pain, and their religion requires them to alleviate pain, and they want to take the other person's life. Consensual. The other person wants their life to be exterminated, right? They want to die.
Can you kind of go over here for exactly what it does again? So it protects religious belief and enforcement of the government to what degree?
Sure. So just to step backwards, in 1991, the Supreme Court decided a case called Employment Division versus Smith. This case involved a Native American who used peyote for part of his religious rituals. Maybe you'll learn about this in con law. The Supreme Court opinion by Justice Scalia, no squish in religion, who said, we agree that this law burdens Smith's religious exercise, but it's neutral. It was enacted to ban controlled substances. It was not enacted to target Native Americans. Therefore, this neutral law is reviewed with what's called a rational basis standard, very differential, and it survives. In the wake of Smith, many people were upset. They said, wait, we can't have this rational basis review. We need something stronger. What RFRA does is to state in federal law that says, if we burden religious liberty, we're applying strict scrutiny, which is much harder to satisfy. It automatically applies strict scrutiny, which requires two things. First, the state must have a compelling interest to burden religion. And second, the state must use the least restrictive means to accomplish a compelling interest. Right? So they have to choose very narrowly tailored means to accomplish that interest, which means you can't burden some people but not others, right? Which is why the exemptions, the question asked a moment ago, comes up. If you're exempting murder and rape and incest, why can't you exempt religion? And this is an issue why under the RFRA, the RFRA, you need to have this sort of heightened pleading standard. This is burden proof for the government. Did that answer your question?
So it makes the burden higher.
Much harder for the government to satisfy. If you're a plaintiff, you want to be litigated under RFRA, not the free exercise clause. Free exercise clause is a lot harder to win.
So, a lot of this goes back to sincerity. I'd love to hear more about Cody's sincerity.
Yeah.
Do you know, are there any examples, or can you explain more examples of sincerely held religious beliefs for abortion that are currently out there?
Sure. So the leading plaintiffs are actually Jews, Jewish women. I think the AP style book canceled the Jews, but whatever. The argument is that in some cases where a woman's health is at risk, the law, the Jewish law, actually compels a person to have an abortion. That is, you have to choose the mother's life over the life of the baby. This is the view of some Jewish women. Not all Jewish women agree. In fact, there's currently in the trial court dueling experts, different rabbis giving different perspectives. Frankly, it doesn't matter, because if some Jewish women sincerely hold that belief, that's enough. But I question whether all these women are in fact sincere. Some might be. I don't doubt that some of them are. But for a lot of these people, there's literally a form online. You can check a few boxes saying, yes, I have these sincere beliefs. Sign me up, right? And there's great incentives for having this belief, because it means you get out of jail free card, right? You get to have the abortion that you want. Other religions, have similar restrictions. For example, they say we have a religious obligation to have bodily autonomy, control over our bodies. Then there's the Church of Satan. I'm not joking. It's actually called the Church of Satan, which argues that they have a religious right to perform abortions, to worship Satan or something. The devil's in the details, as they say. You're welcome. I don't fully understand it. It's not fully sketched out. There are these principles of Satan. I don't know. So again, I'm less concerned with actually what the doctrine of the faith is, because people can make up religions whenever they want. I'm more concerned with, are these beliefs sincerely held? And to use an example, during the Vietnam War, a lot of people who were drafted suddenly found pacifist religions. Oh, I'm a Quaker, right? I'm a Buddhist, right? I want to practice pacifism. And a lot of these guys were just trying to dodge the draft. And the courts were able to probe sincerity. They asked questions: when did you first have these beliefs? Who's your, religious leader? Can you articulate how this doctrine affects other aspects of your life? Or is this just one thing, just you can't engage in war? Maybe one of the ways that I frame it is, are there actions that you would take or not take but for the religious mandate? So for example, I used to eat shrimp. I like shrimp, it's good. I stopped eating for religious reasons. No other reasons, religious, right? What are the examples of where your religion encourages you to do things that you would not otherwise do? Does religion control any facet of your life that you either do or don't do something you would not otherwise do? And if the answer is, well, the only thing that religion makes me do is abortion, that's the only thing, it's very dubious that's a sincere belief. And I think courts should be skeptical. Now, the reason why this is so hard is, imagine a woman who seeks an abortion on an emergency basis because time ticks, right? And she seeks a TRO, a temporary restraining order. Can you really probe sincerity in short order? Do you get letters from a priest, letters from a satanic minister, whatever it happens to be? RFRA is not designed for emergency litigation, which is why they've tried bringing these class action suits. But RFRA does not work on a class action basis. Sincerity is very individualized. You can't impute sincerity to an entire class. It does not work at all. So again, RFRA is not a good fit for a pre-enforcement challenge to a law that affects, half of the reproductive, half the population of reproductive age. Other questions?
So, is under Jewish law, you mentioned the mother's life, is that the only reason that under Jewish law they could tell a woman to have an abortion? Or are there other more complex reasons?
I'm going to try to avoid getting too far into the weeds, but I will answer your question as best as I can. Depending who you ask, it's not just health, it's got to be a serious thing. So for example, 25% of pregnancies have some sort of complications, right? Maybe it's high blood pressure, maybe it's gestational diabetes, right? It might be something that affects women. Another substantial percentage have mental health issues. You have postpartum depression, a range of things. Depending who you ask, which rabbi you ask, the risk of high blood pressure may not be enough. It may be something more serious that could actually either result in the woman dying or something short of that. So when you say the woman's health, that's a very broad term. Does that mean that she might have depression, the risk of depression, and so on? Again, these are very, very hard questions to answer, and I don't purport to do it here quickly. I'm not aware that there are other Jewish religious arguments for an obligation to have an abortion outside of the health of the mother. Some of these other faiths say that even if there's no health issues, you have the right to control your body, and that's your right, and you're going to do it whenever you want. The Satanists, I'm not sure I fully understand their argument either. It's something about Satan. I don't mean to make light of it, but it's a self-professed satirical religion. It's meant to be satirical. I swear this is true. They just opened up a clinic in New Mexico to ship abortion pills, and it's religious abortion pills. Why? They named the clinic Samuel Alito's mother. That's the name of the clinic. They named it after Samuel Alito's mother. Why? They said because when Sam Alito was born, she did not have the right to have an abortion, and so instead she had her son. It's a joke, right? It's meant to be satirical, so I don't think any of it's sincere. I mean, even the ACLU is not representing the Satanists. They have their own council. The ACLU chose the Jews, as it were. Yeah.
There's already for women's health, and like, how's that argument?
It's got to be severe health. It can't be gestational diabetes, right? It's got to be basically your life is at risk or something very severe health complication.
So the religious argument is that they're saying there's low.
Anything. It could be potential for depression. That might be enough. They even cite mental health as a justification. It's a much lower floor. And it's really whatever the woman wants. That's Judaism in particular. Other faiths is any reason whatsoever they want. That's the religion requires it because it's their body, their choice. And to reiterate, the right they asserted in 2000. I'm sorry, the right they're asserting here would stretch all 9 months of the pregnancy, even beyond the standard allowed to Roe and Casey, because it's a right up until your religion thinks it's a person. And these women have claimed their religion says until birth, until the first breath is taken, there's no person. They made that point very clear.
This kind of takes us beyond where we are in Indiana, but on the national level, do you think that abortion is going to come back to the Supreme Court at a certain point, or will it stay with the state courts?
Yeah, it's a good question. I think, to be candid, the U.S. Supreme Court will address abortion in indirect ways. So, for example, can one state restrict the importation of FDA-approved pharmaceuticals that can be used for abortions? Can the federal government permit the shipping of these drugs, or the so-called Comstock law? It's a law from the 1800s which says you can't ship implements of abortion. Can that law be used to block shipping the various abortion pills? There are many different sort of federalism issues that will come up. The RFRA issues, I don't think will come back to the Supreme Court. The reason why is these are all state issues, right? These are all issues on state Supreme Court and state constitutions. There's no federal issue at play. I don't think the Supreme Court will have any authority to rule. There are Buddhists, Unitarian Universalists. These are various other religions. I think each faith has an equally strong claim. The Jewish plaintiffs just happen to be first in line because there's a lot of Jewish thinking on this issue. But I mean, it's kind of a weird one. Just take a step back. So imagine if the court says, okay, you know what? Jewish women, you guys get your abortion. Catholics, sorry, too bad. Right? Baptists, I'm really sorry. You guys, you can't drink, you have an abortion, nothing good for you guys, right? You Baptists, sorry. That would almost be an intolerable regime where certain religions get it right and others don't. That would breed so much hostility and antagonism. And frankly, people would just say, yep, I'm a Buddhist, they baptize me, then abort me. Or whatever happens to me, they'll just make up a religion and they'll join it, which again leads to the sincerity issue. So I don't think it's sustainable to have any regime where one particular faith has it. Or imagine you make up the Church of the Abortion. Right, the entire doctrine is just the right to have the abortion. Again, I think it's not sincere. It's made up. As they say, fake Jews.
So how would you respond if somebody made the claim that we already are there and that it's the Christian faith that is the regime that's why people are anti-abortion?
Mm-hmm. Yeah, and that the argument's being made exactly in court, specifically that the abortion laws are an expression of Christian doctrine, and that legislatures enact laws to basically implement their Christian faith. So there are two ways of addressing it. One is a policy matter. Abortion laws have existed for a long time in this country. I guess Christianity was always sort of prominent. Most laws are based on sort of Christian morality that we had at some point or another, murder and otherwise. So I'm not terribly troubled about that. But the constitutional argument, is there actually an establishment of religion, right? Does the so-called separation of church and state become harmed if religion is being used in such a strong way? And I think the short answer is no, it doesn't. So many of our laws are based on morality. When we elect legislators, we don't elect just blank slates. They bring to their job their own religious beliefs, their own moral beliefs, their own political beliefs, philosophical beliefs. But more pressing, would it violate Supreme Court doctrine? Absolutely not. These laws have really deep roots. They've never been argued to violate the Establishment Clause until fairly recently, and I don't think the courts will set them aside on those grounds. But to be sure, I get why, I understand why the plaintiffs are using religion, because they feel that their beliefs are not being taken seriously. In fact, my ranks have been very heavily criticized by other Jews who don't like them very much, but it's fine. They think that their beliefs are being trivialized, but the sort of Orthodox people, their beliefs are being respected. And there's there is kind of this dissonance, right? Because for the longest time, the plaintiffs in all these religious cases were more Orthodox. They had more devout faiths. They were the Christians, the Orthodox, the evangelicals, etc. And now we're seeing post-Dobbs, the more progressive faiths are coming forward seeking the law. Why? Because Roe protected their beliefs for decades. They didn't need religious liberty. Now they're turning to it. And I'm all in favor of RFRA being applied faithfully. We say in a brief that there are probably some religious people who should have religious right to abortion. We say that point blank. It's going to be a very small number, and not large enough to actually affect a population as big as Indiana, right, with hundreds or thousands of women who want to seek it. So if the law does protect it, then let them have it. Just if I can take another further step back, we're about a 3-hour drive to Chicago. This is all silly. I mean, it's really, I don't mean to be, to trivialize this, right? But the women bringing these suits have the means to drive to Chicago. Their clinics in Urbana, right, going west, right? I've done the math. There are many clinics just about anywhere in Indiana, about a 2-hour drive to a clinic, maybe 3 hours, right? Maybe Texas is a different deal because Texas is really big. So again, I think a lot of this is just sort of, okay, we lost Dobbs, now what? What's the next thing? And even if, they prevail, how many clinics will actually exist in Indiana that can afford to provide the rare religious abortion? Not many. So I don't see this going anywhere. Most of the abortions performed today are performed medically. Indiana law doesn't prohibit the shipment or the receipt of these pills. So at the margin, there'll be some people who perhaps can't travel out of state, right? There will be some people, especially perhaps maybe younger people whose parents don't permit them. There may be bypass laws. There are going to be some rare cases, but even if the suit is fully successful, I don't think it will achieve very much.
That's a good question. Texas. Where are you guys?
We're right by Mexico, right there in the south of the.
That's good. No, like where are you on? What's going on?
Texas has a full ban,
Full ban?
basically from the moment of conception, yeah.
Oh wow. And has that received any challenges at this point?
Oh yeah, my God, yeah, all the way up and down. Texas had a lot of litigation against its ban. Nothing stopped it so far. Yeah.
Do you guys have a RFRA?
We do have a RFRA. Yeah. Groups have tried it. For whatever reason, there's a single judge in Marion County who was first out the gate. Other judges have not been quite so fast on it. There's judges in Florida. There's cases, I think, in Colorado or Utah. No, it's not Colorado. There was a case in Utah and a few others. But the Texas one hasn't had any successful challenges. I think for the reason why is that for the most part, okay, these numbers are a couple months old, but in the wake of Dobbs, the number of abortions nationwide decreased just marginally. I think most women are still getting the pills they need to have the abortions, one way or another, or they're traveling to get out of state. The clinics will have to reallocate their authority. I mean, all these clinics are open up in New Mexico on the western border, right near where El Paso is, right near where Texas is. At present, Oklahoma still has some facilities open, so it's the north they have it. So between the medication abortions and otherwise, the total number of abortions hasn't decreased as much as people feared they would. But from my perspective, all this is political, right? All that can happen in politics. Just don't distort RFRA. Leave RFRA alone. Leave Brittany alone. Leave RFRA alone. What else?
So you mentioned like the other case in Indiana, the religious liberty.
The Liberty one, yeah.
What are your thoughts on that?
Yeah, the other one is based on the Indiana Constitution, which I don't have in front of me, but it has like a right to life, liberty, and something or other. What was it? Do you know the phrase? It's basically a paraphrase of the Declaration of Independence. I don't remember the exact wording. And the argument is that this provision protects a right to abortion, right? So how do you read a state constitution that protects the right to liberty? What does liberty mean? Well, perhaps one way is just to say whatever the Supreme Court says the 14th Amendment means, that's what our state constitution means. That's just lazy. That's just wrong, right? Constitutions were written at different times for different people, different words. And Judge Sutton, for example, teaches we should look at state constitutions very carefully. I think Sutton is right. As I understand the Indiana one, Indiana banned abortion before, during, and after the current Constitution was ratified. It will be very striking to say that the people who drafted that Constitution and banned abortion actually intended the Constitution to prohibit a ban on abortion, right? It's just to be a very bizarre argument. Well, you'd be surprised. But that's if you take a historical argument. If you take the idea that liberty is a sort of evolving concept that isn't frozen in time, but that takes its context from the people and what they do, then you can make the argument. Recently, you had a South Carolina Supreme Court decision that found a right to privacy, which has been in the Constitution for 200 years or so, actually does protect the right to abortion. Go figure. Kind of. It was a very weird opinion. There were actually only 2 votes to that position. The third vote of the 5-member court went a different way. You have Idaho saying, no, this is nonsense. We've banned abortion in Idaho for almost 100-something years. There's no constitutional right to abortion. So again, state courts are where the action is. It's not in the federal courts. What else? Anything else? Donuts?
Yeah.
Donuts. Thank you all so much.
Thank you so much.
Thank you.